Good morning, Dr. Rifai, and welcome to the Center for Medical Justice. My name is Dr. Joseph Parker, and I will be interviewing you today about your recent experience with the DEA and the Department of Justice. To start off with, could you tell me a little bit about yourself?
Thank you for having me talk to your audience. My name is Mohammed Aly Rifai. I'm a physician licensed in the Commonwealth of Pennsylvania. And by training, I am an internist and a psychiatrist. I'm board certified in internal medicine and board certified in psychiatry and consultation psychiatry. I'm also double board certified in addiction medicine and have been practicing for almost 25 years. I'm originally from Syria, and I've been in this country for the majority of my life. I have a big family, a lot of physician relatives in the area. I describe myself as a father and a husband. My wife is also a physician. She's an OBGYN. I am the father of 3 kids. 2 of them are in college. 1 is still in school. I am a healer. I am a researcher. I've done a lot of research on psychiatric topics, including telehealth and psychotherapy. And both of these topics of research were a big source of my trouble with the Department of Justice, and we'll talk a little bit about that. Following my training at the University of Virginia, where I did a combined residency in internal medicine and psychiatry, I traveled to the National Institute of Health, where I worked at the National Institute of Mental Health for about 3 years as a junior physician, and then relocated to Pennsylvania, where I've been for the majority of the last 20 years of my life. Initially, my work was with a local health system where I was their medical director for their inpatient psychiatry unit and the psychiatric emergency services for that health system. This was one of the pioneering and first experiences doing telehealth. In 2006, we started an emergency psychiatry telehealth system, telepsychiatry. No one had heard about telehealth and telepsychiatry at that time, and this was one of the pioneering experiences. We connected the emergency rooms of 3 separate hospitals and saw patients in remote locations to disposition them and treat their psychiatric issues. This was my pioneering experience, and I continued to work with telehealth as I transitioned into private practice. One of my other areas of focus of expertise and interest was psychotherapy and talk therapy to patients. So I specifically participated in a national guideline on individuals who were suffering psychiatric issues in nursing homes and emergency rooms, and we developed a national guidelines on verbal de-escalation of the agitated patients. And we published that in 2012. In 2012, I decided to go into private practice and started my practice, Blue Mountain Psychiatry, which is still in existence till now. And this is part of my trouble with the Department of Justice. I came under the interest and focus of the Department of Justice in 2015 for my telehealth and psychotherapy work.
Now, let's explore that a little bit, because I've noticed that several telehealth companies, Dunn Health, several others are being targeted. I think Cerebral had some issues. It seems like the Department of Justice is trying to, while you've got one side of the federal government saying telehealth is necessary and works, there was a recent study that showed that it is in some ways better than an in-person because it's more available, right? And it's easier for the practitioner to treat more people. It's easier for the person because it is a lot more personable actually to get somewhere you feel safe in and pull something up on your phone than to have to go to an office and go through all that every time. But it seems like the federal government is, or someone motivating the federal government is very much against telehealth. And I was unaware of the extent of your credentials. You worked at the National Institute of Mental Health,
Yes,
and
yes.
it seems to me like, and you actually have like, you studied telehealth academically. It seems to me like you would be the type of person whose opinion the government would defer to on these matters. Um, but of course, Dr. Ruan had 7 board certifications, and I just saw where the judge gave him back his original sentence, right? The courts had said, give him some, uh, after Ruan, they had said he was unjustly convicted of these crimes, therefore take those off. And the prosecutor said, well, let's recalculate so he gets the same sentence. And the judge said, okay, let's give him the same sentence. So even though he won in front of the Supreme Court, and people will quote Ruan as
Mhm,
precedent
mhm.
for decades or perhaps centuries, it did him no good whatsoever. He and Dr. Couch are both in prison for the same period of time. Do you feel like that came close to happening to you?
Sure, absolutely. It's only by the grace of God that I'm here. I'm here talking to you.
Now,
Some of those experiences that physician experience in terms of prosecutions are felt to be an attempt to teach a lesson to others or make an example of individuals who may have not done anything wrong, who may have done some pioneering work and were the kind of the forerunners. And in my case, I had done a lot of telehealth work prior to the COVID pandemic and the start of the kind of real telehealth work because of the severe need for that. But since 2012, I had done a lot of telehealth program, and there was no sensitivity or interest in exploring that what was the work that I was doing. So, for example, one of the reasons why I was targeted is the statement that the work or the billing that I was doing was different from my colleagues or from my peers. Well, it was sure different because I was the only physician who was doing telehealth work in the Commonwealth of Pennsylvania. In my district, I was the only physician who was doing that. So when they say, well, why is this person is the only physician? Because nobody else was doing it. I was the pioneering work. And it was quite unfortunate that some of these statements that are made that the work is not billable or the work is fraudulent were made without any reliance on any experts. They were done just based on opinions of the prosecutors. And that was demonstrated in court because the government did not bring any experts. And that's a public knowledge that during the trial, they never brought any experts to dispute the quality of my work. I brought in a coding expert. I brought in a psychiatrist who'd done similar work. And they testified that my work was pioneering work, providing adequate, appropriate, and compliant services to individuals who are in rural nursing homes, underserved rural nursing homes in Pennsylvania, and that these services helped these individuals who are Medicare beneficiary to a significant degree. And so this was part of the entire premise of providing fraudulent services, or what the government called, well, Dr. Rifai stole from Medicare. It was actually, we provided services at a significant loss to myself and my practice, and that those services we actually made no money on.
now let's explore that a little bit because it's been my experience. I've looked at hundreds of physician prosecutions. In about 80% of the cases, I can find absolutely no criminal intent, no true criminal conduct. just the government saying he did things differently, or we don't like the way he did things, or we don't like the patients they saw. I would suggest perhaps they didn't bring any experts to your trial because they could not find any willing to make what would have been false statements necessary to ensure your conviction. Whereas when most of these physicians are brought up on opioid prescribing charges, there are a half dozen experts willing to, for the right price, say things that are contrary to the CDC guidelines, to the general practice of medicine. So I think that's probably why they had no experts there, though we have no evidence of that. But I'm sure they would have had some had they found someone willing to say it. Now, let me ask you this. Do you think that federal interference in the practice of medicine is persecuting what I will call the exceptional practice of medicine? And let me say why I think that. The government is confusing usual practice of medicine with the average practice of medicine, a common mistake that lay people, non-scientists make. And by doing that, they are saying if everyone else is doing it this way and you do something different, you are by definition outside the usual practice of medicine, and we therefore can prosecute you, despite the fact that you might be doing something revolutionary, innovative, and exceptional. The first physician to travel to Europe and learn a new surgical procedure and come back and perform it here is not practicing the usual practice of medicine, because nobody here has been doing that. So if you went back to 2012 or whatever, establishing national guidelines for telehealth, then you're right on the cutting edge of this, of telehealth itself.
Sure. And the other service that we were on the cutting edge of was talk therapy with psychotherapy. I had participated in a national guideline where we taught psychiatrists how to use their talk therapy, their skills to de-escalate difficult situations, to calm down individuals who are upset, whether in person or by telehealth, and develop that national guideline for the American Association of Emergency Psychiatrists, as well as the American Psychiatric Association. And the topic of psychiatrists doing psychotherapy or talk therapy was not a pill that the government was willing to swallow, even though psychiatrists are the origin of psychotherapy. Sigmund Freud was a psychiatrist. He was a physician, and he's the one that started the movement of psychotherapy. The government's vision of psychiatrists was that they're going to do medication checks. They're going to do quick medication checks, quick visits with no talking to patients. Just, okay, Mr. So-and-so, here is your pills, here's your prescription, you go on your merry way. And there was no interest in the psychiatrist talking to the patient. Nonetheless, the American Medical Association, in their current procedural terminology, and Medicare had significant interest in psychiatrists exploring psychotherapeutic topics with their patients. They didn't want psychiatrists to actually just give medications and not talk to the patient, not do psychotherapy. So there was guidelines from Medicare, there were guidelines from the American Psychiatric Associations that actually encouraged psychiatrists to talk to their patients, to not just prescribe medications and not talk to their patients. Unfortunately, there was a disconnect between what the Department of Justice thought and wrote in their prosecution and actually what Medicare wanted. Complete disconnect. And they were on a different planet in terms of understanding the practice of psychiatry, and especially with telehealth. And I think that was easily demonstrated to the jury that saw that there was a disconnect between what the government was claiming, that what we were doing were quick sessions of medication management and that the psychotherapeutic services that we were providing were not valid. And I think that was easily demonstrated to the jury that these things were actually valid, and we were successful in being able to have the jury see it our way in terms of the validity of the services that we provided.
Do you feel that the DOJ, to a degree, first, that there is clearly a disconnect between sort of the educational branch of not the DOJ, but of Medicare and I would say DHHS, right?
Sure, sure.
Department of Health and Human Services is the only federal agency that the Supreme Court has said has the right to even promote a medical opinion. They've made clear
So,
many times that it's not for the DOJ or the DEA to decide what is and what is not a good doctor.
so the prosecuting agency for my charges was actually the Office of Inspector General for the Department of Health and Human Services. But those agents are lay individuals, college educated or master educated individuals with no specialized medical care. And there was no input from somebody with a medical degree, except for a registered nurse who acted as a coder for the government and provided expertise. And fortunately to me, and unfortunately to the government, her opinion was not valid either, and that was proven in trial. So I think that the important fact is to always bring in an expert that would bring in your point of view and the usual pattern of practicing in your profession, rather than extreme views about how things should be practiced. And the hope now that juries would listen more and would understand, especially if it's explained to them in simple language. The government's presentations were very complex, that no one can understand this, while my attorney simplified things and was able to present a simplified case to the jury for them to understand.
So for the defense attorney, for the defendant, the arguments need to be simplified, clarified, and common sense. Is that
As simple as possible? Simple and clarified and common sense. I was fortunate that I chose an attorney who came from a family of psychiatrists. His father was a psychiatrist, and his father was actually a pioneering psychiatrist who provided mental health services in the community in the Philadelphia area. He did that in the 60s and 70s, and there's actually a professorship named in his name through University of Pennsylvania. His brother is also a psychiatrist, so he is somebody who grew around psychiatry and understood the field of psychiatry. And when he heard about my case, he thought that there was significant evidence that was in my favor, and he agreed to take my case. He did a wonderful job.
So he had a concept and a basic understanding. Of course, being the son of a physician, he will understand a lot about medicine just sort of by osmosis. You know what it's like, the long hours,
Sure.
everything else. And also, I think he kind of had some skin in the game. So there was a combination of two things. He cared about what was happening to you, right? Because of just knowing what it's like for someone to be a physician, someone you care about to be a physician. He also had the impetus, the desire to make sure you were treated fairly.
Mhm.
And then he seems to have had the skills. So what was his specific specialty of law?
So my attorney was a public defender during the early periods of his career. He was a public defender, federal public defender, as well as a public defender in the local court in the city of Philadelphia. He is currently actually the president of the Public Defenders Association of Philadelphia. So public advocacy was a big thing for him. But he's been in private practice now for almost 25 years since leaving his role as a public defender. He's always been a civil right attorney, and he's done white collar defense cases, and he had a great track record of winning cases. He also spoke very well to juries. I mean, so he has at least 300 trials under his belt.
Okay.
So one of the things that a lot of federal defendants, physician defendants who are facing federal criminal prosecution don't understand is that the trials, the federal criminal trials, are almost a non-existent breed anymore. So there's less than 2,000 trials per year happening in the entire federal system. I looked at the statistics. Less than 2,000 trials. So if you divide that on the number of judges, each district judge will probably have less than 3 trials per year.
That's surprising to me.
How many prosecutions that the federal prosecutions do? So even the line prosecuting attorneys, they're not seeing a lot of cases. So if you have an attorney, if you have a defense attorney who's had lots of trials, lots of defense trials, and you have the prosecution that doesn't have that much experience, and you have to be also very sensitive to the judge. I mean, so for example, my judge, he's been on the bench, on the federal bench for almost 10 years. Based on those statistics, he probably only saw 30 to 40 trials throughout his whole time on the federal bench. He's probably seen more trials. He was a local circuit judge in the Commonwealth of Pennsylvania, so he probably saw more trials there. But on the federal level, he hasn't seen a lot of trials, and that's not specific for my judge. Probably every judge. So the federal criminal trial is a disappearing breed. There's no more trials going on. And so these are unique experiences, and only if your attorney has done a lot of trials that you should go with an attorney. You should ask that question. How many trials have you done? When a physician is facing federal criminal prosecution, they should ask their attorney, how many trials have you done from beginning to conclusion? Jury selection is a very essential skill that the trial attorney need to have and need to implement and put that into action, so you could be able to choose a favorable jury for your defendant physician. And I saw that on demonstration of how we were able to select within the parameters of the federal system a favorable jury. Even though the government thought that this jury was not going to be favorable, we selected a favorable jury that was impartial, that was fair, that listened to us, that had interest into the case. We had several Medicare beneficiaries on the case. We had several individuals who were in psychotherapy and seen psychiatrists in the past. So there was interest from the jurors in the content of the case. They were attentive, they listened very well, and saw the wonderful care that we had provided to our patients and came with the favorable verdict to me.
Now, only 1 out of 250 federal defendants choose to go to trial, right? 0.4%, I believe, is what it comes to be, or somewhere around there. That might be.
So the statistics from the U.S. Sentencing Commission for 2022, we don't have the 2023 yet, numbers. There were 71,000 prosecutions, indictments, prosecutions in the United States in the federal system. Only 1,700 decided to go to trial. 1,700 and a little bit. And out of those, 290 were found not guilty.
Now, I would argue that those statistics are very close to those of the former Soviet Union when you went to trial. I've actually done quite a bit of research on the former Soviet Union. And part of their argument was that even if this defendant was not guilty, and it was part of Soviet legal doctrine and accepted and sort of what they considered a reasonable thing to do, even if this specific defendant was not guilty, if their prosecution would somehow further the needs of the state or benefit society in some way, it was okay to prosecute. Do you feel like this is what we used to call a Russian warning shot? A Russian warning shot is where they go into a room of unarmed people, shoot the first person, and then tell everybody what the rules are. It's a very effective way to terrorize people and make them do what you want. And it's one of the reasons that concentration camp guards, you don't need 10 guards per confinee like you would expect. You only need one guard per 100, or sometimes even per 1,000, because of the fear that's instilled. Do you think that to a degree they are trying to take out people who I believe are obviously trying to do good to terrify everyone? Because if you only take out the truly guilty, you can't dictate the direction medicine goes. If you take out someone like yourself or like Dr. Bauer, you will clearly terrify everyone. Dr. Bauer, I don't know if you know him, 81 years old, 50 years of humanitarian service as a neurologist, pain specialist, now in federal prison, because we all need to be protected from 81-year-old, physicians and their dire, habits of I guess manhandling people. I don't know. It makes no rational sense to me whatsoever why that man's in prison. But you came very, very close to that. What gave you the courage to say, no, I'm going to fight it? Because I can tell you that thousands, tens of thousands of innocent people a year say, I'm too scared to fight it. I'm innocent, but I'm going to take a plea because they have stacked all these charges on. Well, look at Dr. Meredith Norris. She's looking at a possible 300 years in prison. Of course, only serve 85% of that, so that's what, 270? It is a terrifying prospect. What gave you the personal courage to take this risk?
So a big part of it is I also come from a family of lawyers. My grandfather was actually an appellate court judge. So I have a little bit of knowledge in the legal system. I have been involved in the legal system as an expert witness throughout my career, and I've had opportunities where I testified in federal court and in state court as an expert witness. One of my most notorious experiences was testifying as an expert witness in a death penalty case. And this is a death penalty case where an individual who had significant psychiatric issues shot in broad daylight his ex-girlfriend, her boyfriend, and a little child. And this was a significant event in that area, but the individual had significant psychiatric issues, very significant since childhood. And so I was on the stand for 7 days being grilled by the state district attorney, who wanted to inquire from me about the severity of this person's psychiatric issues. We went through voluminous state hospitalization for this person, his school record. We went through it with a fine tooth comb. And ultimately, based on my testimony, the individual actually was spared the death penalty, because this was a death penalty case. and the jury decided to spare him the death penalty after 7 days of testimony from me. So I've been through the rigors of the legal system. As a psychiatrist, I've also done legal work through the mental health court systems here in Pennsylvania, where we actually advocate for individuals to stay involuntarily in inpatient psychiatric units. So I've had significant legal exposure and legal experience in the system. But to tell you the truth, I was terrified. I was terrified. I mean, from my perspective, I was going to federal prison. I was going to federal prison to the extent that I went and visited the designated facility that I wanted to go to. I went to the federal facility in Otisville, New York. I even contracted with a mitigation specialist to prepare me for jail and went and visited that facility. So any federal criminal defendant has to prepare himself based on the statistics and numbers. You prepare yourself for jail and then hope for the best possible outcome and fight like hell, because you never know what you may uncover in your evidence once the government starts doing discovery and giving you evidence. And in our case, we found exculpatory evidence that helped me in trial.
Did the government disclose that evidence, or did your investigators find it?
The government disclosed a large swath of evidence. They had gone on a collection frenzy to collect a significant amount of evidence that they probably never looked at. We are pretty confident at the amount of evidence that they had collected that there is probably, they never looked at 99% of the evidence that they collected. So one of the main issues that actually brought me to the attention of the Department of Justice, Office Inspector General for Department of Health and Human Services, was some patient complaints in 2016 and 2017. The patients were complaining that my practice had sent them bills for the balance for the co-payments that they were owed, that were owed to my practice. And these patients complained that they've never paid any co-payments in the past. And now this practice is asking me for co-payments. And this was a very important topic in the trial. And with the grace of God, with my investigation, with the investigation of my coder, with the help of our investigators, we uncovered a document from Medicare in 2018, where Medicare actually owned up to the fact that their computer system, the billing system of Medicare, actually was malfunctioning in 2016 and 2017. And patients were being sent an EOB, explanation of benefit, telling them that they owed a copayment while they didn't owe a copayment. And Medicare, in writing, wrote that due to unforeseen circumstances, this was the exact wording, due to unforeseen circumstances, patients were sent EOBs that reflected that they owed a copayment while they in reality did not owe a copayment, and we want to correct this. They took that part of the system offline for 4 months to correct it and never told doctors or providers until mid-2018 about a situation that happened in 2016 and 2017. And so we actually showed that document that the government had in their possession, but they didn't know about. They didn't know that this was happening. And this was, I think, from my perspective, this was a turning point for the jury, because the agent who was being cross-examined was surprised and did not know that what they were investigating as fraudulent activity was actually related to a glitch in the Medicare system.
So you end up getting prosecuted for an error that the government made because it's one hand doesn't know what the other's doing, or because they didn't carefully review the evidence for signs of innocence. Do you think that's a flaw in the way they approach these prosecutions? That they do not look for signs of innocence or disregard them? I would say sometimes even hide them, and there's evidence to support that.
Well, I mean, look at it from the perspective of an agent, either an FBI agent, a DEA agent, an Office of Inspector General agent investigating a case. 99% of defendants will plead, will take whatever evidence they collect, whatever charges they stack, and will take that at face value. The lawyers are not willing to fight. Why would you do anything? I mean, just look from the perspective of the prosecutor. They're not going to give you anything. They think you're guilty. You're guilty until you're proven innocent. The other way around, not you're innocent until you're proven guilty. And that's by default related to the system. I don't think it's anybody's fault or anybody does it on purpose, but that's the system that we've gone into now, a conveyor belt of conviction system where 99% you're guilty, and only the lucky ones or the ones that get some grace from God that are found not guilty. So there's no interest in giving you any exculpatory evidence. They will give you all the evidence and you find anything that's exculpatory to you. But I think this is the system that we are in right now, and it's quite unfortunate of how these outcomes are stacked against physicians who fall or are affected by any federal criminal prosecution.
That is a very important point. And also, I think your case is an incredible exception. You're a physician with legal knowledge, having been in a family of lawyers. Your attorney is a civil rights attorney and public defender and federal public defender. And I would say from my conversations with gentlemen from that area and ladies from that area of practice, that they are a little more skeptical of what the federal government says in the average person, to the point of they generally don't trust anything that they're given. They believe it's been either willfully or just.
I don't think he didn't trust anything that anybody gave him, neither the government nor me. So in my case, I had to prove to him that what I'm saying through experts, through additional evidence, I had to prove to him, it's like, this is our case, and here's my evidence.
But that allows him to then prove it to the jury.
Yes, point by point in writing.
Perfect, excellent. I think it's extraordinarily exceptional that it would go the way that it did, but I can see why, because all of these unlikely confluences sort of come together to come out with what turns out to be a benefit. Now, I want to ask you something. Local authorities are quite often also involved in these operations. And when you are an expert witness in a famous case like you were, and you thwart the will of the local law enforcement, perhaps even at a state level,
sure,
it is not impossible that when your name comes up, someone looks for a reason or jumps to a conclusion because they want to. I have noticed that those who are expert witnesses for the defense in federal trials have a very high rate, physicians who have a very high rate of being themselves later prosecuted, much higher than the general population and chances would allude to. And as you say, because these are complicated cases and they throw a ton of data at you, the jury is swamped in that data and doesn't know what it means. I'll give you an example. A doctor here in Arkansas was prosecuted, and they quoted so many hundreds of thousands of morphine dose equivalents. And I'm not talking about me, another doctor. So many millions of or hundreds of thousands of morphine dose equivalents to this many patients over this much period of time that he was treating for pain. I did the math on it. Oh, they said pills in his case. Now you never know if they really mean pills or if they're talking morphine dose equivalents, because they'll say morphine doses to the media and the media will think that's a pill. But when I did the math on it, it worked out to 2.5 pills per day. An absolutely reasonable amount for him to be prescribing. But because they multiply it all up, it seems impressive to the jury, which is why I think charts and graphs and simplifying things for the jury is extremely important. And I have to say, most lawyers are abysmal at that. And I would argue your lawyer would have been too had he tried to decipher the medical facts himself. But instead, he put that onus on you, which I think was brilliant, because that gave you the opportunity to put everything together and prove to him. And of course, he's skeptical. He's going to question this. He's not going to let you get away with, but I was doing the right thing. Prove to me you were doing the right thing. What do you have to show that? Do you think your digital skills, your computer skills helped you prepare your case?
I think that it was very helpful. We also utilized the digital skills of a company that helped us a lot with the processing of the evidence. So I truly, I know you talked about the fact of that in my case there were a lot of exceptional things happen, but I think for a physician who's facing federal criminal prosecution, these conditions could be replicated. There is an opportunity to replicate these conditions. Obtaining the computer system that would be able to process your evidence very easily, obtaining an excellent investigative team. So, for example, in my case, we hired a very prominent investigative group that had a good track record of success. And they were very, very helpful because they knew exactly where, as you say, where the skeletons are buried. They did not leave a stone unturned in terms of doing a very thorough investigation to tell the lawyer, yes, we think there is significant evidence to support this physician's contention that they are not guilty of what the government is claiming. Being able to get the assistance of coders if the case involves issues related to coding, healthcare fraud, or being able to get the assistance of, for example, a toxicologist or a psychopharmacologist in cases of controlled substance violations, and as well getting the assistance of an expert physician who can explain to the jury in plain language what is going on, what is this case about, and whether it actually differs from the routine practice that they do in their own practice. And preferably, this person, this physician, should be somebody who's actually practicing and could impart on the jury their actual real life experience practicing medicine. And in my case, practicing psychiatry and practicing psychotherapy. My expert psychiatrist physician said, this is bread and butter psychiatry. This is what we do every day. And the government is coming and telling you that this is not the way it is. They want the doctor to just give people a prescription, a pill, and send them on their merry way. This doesn't happen. We talk to our patients. We do psychotherapy. This was done in this case, and the jury listened to him.
The funny thing is, they prosecute other doctors saying, you should have talked more, you should have done more psychotherapy, you didn't do your biopsychosocial. So there are physicians treating pain who just treat pain that end up being prosecuted under the argument that they should have been more like psychiatrists. And then when a psychiatrist actually engages in psychotherapy, which in I believe most rational points of view would be one of the most important things a psychiatrist does, right? Then you get prosecuted because they say, well, that's not what you should be doing. And I think that's where we have a problem between what they think you should do and what the law says you cannot do. The law says nothing about a psychiatrist not engaging in psychoanalysis or
Sure.
anything else a psychologist does. A
Sure.
psychologist cannot prescribe, but there's everything a psychologist does can be done by a psychiatrist, and you're actually trained in similar things. And I think sometimes that escapes the judges also, perhaps not in your case, but I have seen a recent case where a physician was prosecuted and the judge told the jury, you cannot find the doctor guilty of a crime unless he prescribed a controlled medication in a clearly illegal way, like to someone with addiction.
Mhm.
Well, that's not true. You can treat pain in someone with addiction. You can prescribe opiates to someone with opiate addiction, as long as you're prescribing it to treat the pain and not to maintain the addiction. That was the standard set by Moore after the Controlled Substances Act. I think the CSA was passed in 1970 and Moore was in 1974. And the Supreme Court said, well, yeah, you can't maintain addiction. And that goes back to the 1914 Harrison Narcotics Act, which first said, you can't treat addiction basically, but it never said you can't treat pain. But back then, I think 30,000 doctors prosecuted and about 5,000 went to prison back in 1914. And the Supreme Court said, this is crazy, stop it. It seems to me in Ruan, they also said, this is crazy, stop it. And that's being ignored. Now, in your case, these are fraud charges, so it comes more under the recent ruling of, I think, Loper, where they don't get to just define anything any way they want to anymore, which had been allowed. Now, I want to make sure the investigative group, I believe, was the Chapman Law Group, right?
Yes, yes.
Tell me about this evidence processing service, because I was completely unaware until you told me about it, that these things existed. So I'm, we're trying to do this at home because my lawyers were not tech savvy. Go ahead.
So we used a service that is it's pretty expensive, but it's in the Philadelphia area. The company is called Cornerstone Discovery, and they use a software called Junto, Gunto. And the Junto is a artificial intelligence enabled search engine where you could actually load your discovery, and it will process everything. It will process medical notes. It will process emails. So you basically can search different terms, and you can divide. You can tell them where to search. You can tell them what to search for. Different terms. It can search emails. It can search documents, and it's equipped with artificial intelligence because it processes the evidence. When the evidence is fed into it, it processes the evidence. It processes everything. So I was very successful, and I'm very lucky to use that. And I got to learn it. I had a year and a half of learning experience to be able to understand how to use the software, how to search for different things, and was able to basically leave no stone unturned in this huge discovery that they collected and never looked at. They looked at, for example, they did a search warrant and they got my emails for 7 years. I don't think they looked at it. I mean, I don't think they looked at those emails. They just collected an amount of information to make it a gigantic effort for any defendant to look at the amount of evidence that they have collected and say, oh, they have so much evidence against me, I'm not going to fight. But I knew that there was not going to be any emails that are going to be against me because I knew all my emails. I knew what I write. I knew that there's not going to be evidence where they're going to point to, aha, this is the evidence against the defendant. There was nothing of that sort. But I had to demonstrate to my attorney that there was no evidence in that whole set of evidence that they had collected that was going to be pointing to any guilt. The other issue, I think, in my case, and I think a lot of defendant physicians should use that to their advantage, is that they never expected the case to progress to that stage. They never expected it to go to trial. So they were ill prepared. They had collected the evidence, and they kept asking my attorney, when was I going to submit a plea agreement? And he said he's not going to plea. He wants to go to trial. I think that could be used to the advantage of a physician defendant who's facing federal criminal prosecution, that you need to go to trial and you need to prepare yourself and you need to put all these pieces together. And I think it is something that could be replicated if we develop a system where physicians have checklists of things that they can do to counter what the government is doing in those criminal prosecutions. There's a way where we can unwind this system that is churning through physicians every year with these federal criminal prosecutions. So, for example, I did some work on the statistics. How many physicians are charged every year with healthcare fraud? And I'm not talking about controlled substances. I'm talking about healthcare fraud. There's about 350 physicians every year. And the number has been steady since 1996. That's when the healthcare fraud regulation was passed as part of HIPAA. The Health Information Portability and Accountability Act was not just HIPAA and patient privacy. They passed 18 U.S.C. Section 1347. Healthcare fraud regulation was passed hidden into the HIPAA regulation of 1996. And since then, it's been almost 28 years, 27, 28 years. Like clockwork, every year they prosecute about 300 to 350 physicians. And their average collection in terms of how much they recover is between 1 million to 1.5 million. That's the average collection that they have. And do you know what? It turns out to be that is the budget for the Office of Inspector General for the Department of Health and Human Services, which is $450 to $500 million. Basically,
I just had that discussion with another doctor about the DEA. He had done the same math you did and found the same thing, that the amount of seizures that they do basically nullifies their budget. That's very, very interesting. I had no idea. Now, I do know that with the 2012 Affordable Care Act was also passed an amalgamation, a joining of federal forces and very, very large health insurance companies like Blue Cross Blue Shield, big ones like that. And that the Wall Street Journal just said that, and I'm not saying Blue Cross Blue Shield did it because I'm not positive which company it was that did it. I don't remember, but that these big companies were adding diagnoses that the doctors had not put on to make sure they could get paid more. So they added cancer, HIV, things like that, and to the tune of $10 billion. So while they're stomping Dr.
Oh, no, $50 billion.
Oh, $50 billion.
50, your
What's a
numbers.
billion here or there? You know, once you're in Elon Musk range, it all becomes just numbers. So while they're spending so much time and effort trying to stomp the doctor who is basically creating the possibility for telemedicine so that people in rural places, and I am from a rural state, I can tell you right now that it is not easy to find a specialist in anything around here, which makes general practitioners have to do multiple things. There was a time when I was both the director of emergency medicine, working in the emergency room, and the hospitalist, taking care of everyone in the hospital at a little county hospital. Now, it wasn't huge, but I was the only doctor on that floor. So anything that happened, that was me. That's how rural places go. We can't afford to be helicoptered every time we get sick. You'll die before you get there. We're too far from places. So I'm wondering, these AIs, now you were talking about Junto and the AI that was developed by this company, and it can read PDFs, I assume?
Yes, it can process PDFs and read PDFs. Yes.
Wow, that is just astounding, because one of the hardest problems I had was trying to get the attorneys I was using for my trial to actually go through any of the evidence, because it was just too confusing. and frankly, they don't understand the words. You know, I can say cephalgia and they'll have to look it up, and it's just a fancy way of saying headache, but they don't know that. And it's frustrating for them because attorneys are specialists at what they do, and that's usually good enough for almost any trial. But when you've got a trial that is extremely technical, where where the science really determines what the outcome, you know, or should determine it, you've got to have that sort of knowledge. So I think AIs are extremely good for that. But the government is using AIs to target doctors, and their AI was trained in 2017. It was started by Attorney General Jeff Sessions, and it was trained with information provided it by very large health insurance executives, healthcare company executives, and the DEA. There was almost no medical doctor or specialist input. So we've got an AI that believes that if you prescribe a lot of medications, you're criminal. If you prescribe a lot of opiates, you're criminal, even though that's what a doctor doing pain management, or definitely a pain specialist, that's going to be your main medication. That certain combinations of medications are criminal, even though we should avoid certain combinations when possible. Sometimes the benefits outweigh the risks. You've got rational polypharmacy. You've got all these reasons to do things, but they want it to be usual and average. They want cookbook medicine. And it sounds like that's what they wanted from you. They wanted you as a psychiatrist to prescribe an antidepressant, and then they say it's not your place to do the psychotherapy, when that's not their judgment call, in my opinion. Do you think that's what was happening?
I think that's partially what happened, and because because it was difficult for them to prove that some of the findings that they were trying to present to the jury, they also wanted to bring in simple errors that could happen in any practice. One of the main issues that they brought was actually billing on deceased patients, and there were some errors where that the actually billing person of my practice admitted to on the stand that she had some data entry errors. But I think we were also able to demonstrate, even though the government tried to present this as a scandalous finding, oh, look, Dr. Rifai billed on deceased patients, we were able to actually drill down because of Junto and because of the investigative team. We were able to drill down into the granular details of some of the government findings. And for example, we were able to present that some of the patients that they indicated that I billed on deceased patients actually died before I was born. I think that really resonated very well with the jury, because that was a moment where there was silence in the courtroom when the jury heard that, and we demonstrated that as my lawyer cross-examined the government's expert who was going through these numbers, and showed the jury that, okay, these patients looks like they were born before 1973. Are you aware that my client was born in 1973? How would he have billed on these patients? He wasn't even on the face of this earth.
You mean they died before 1973?
They died before 1973. So that actually showed how that actually the data collection, and this was probably collected by an AI bot that was developed by the Center for Medicare. And Medicare has a huge database. It's called One Medicare Place. They have a huge database that includes all the billing that has done on Medicare. I think it goes back to 1945.
Wow.
They have a huge database, and it's that One Medicare Place. And then they developed these bots that would go and pluck these data. And so the question for that bot was, well, go collect us all the data that was all the billing that was done by Dr. Rifai and his group on deceased patients. Now, this bot probably collected invented data or data that it was thought it was right, but we actually were able to demonstrate that like ChatGPT, when you ask ChatGPT to write a legal brief for you, they will refer to it will invent cases. There have been cases that lawyers got in trouble with the courts because they relied on ChatGPT to write legal briefs for them, and ChatGPT invented cases to reference in support of that legal brief. The same case here, that AI bot invented patients that thought that we build on deceased patients, but ChatGPT is not, it does not understand that, well, this practice owner was born in 1973, so you can't get patients who were deceased before 1973.
So what we've got is an AI that's hallucinating, as they all do, because these neural nets are prone to, just like human beings, to a type of artificial pareidolia, where they see something where it's not because they expect to see it, right?
Yes,
So
yes.
maybe there was a similar name, or who knows why. I know that I use AI a lot, and I think AI can be tremendously helpful to medicine. My problem with what the Department of Justice is doing is that they are turning our Fourth Amendment over to these AIs. And once the AI says something, they're taking it as gospel. They're not first, they didn't train the AI right. They didn't vet it. It's extremely error prone to the point that there's a Freedom of Information Act request that a fellow physician, Dr. Neil Anand, is using to try to pry the training data, the training data sets, and all that from the government when it trained this AI. But one of the things we found was that after they developed it and did a little testing of it, it had an 84% failure rate at detecting risk of addiction, of overdose. Yet they ran with it, and they're prosecuting doctors for putting their patients at risk of overdose and sending them to prison for decades based on a device that they knew was 84% inaccurate. And they get away with it because, one, they say it's proprietary because they're hiring private companies to do it. If it was a government-made AI, they would have to produce it. Two, they are saying that they skipped past the FDA. The FDA says if you're using a device to make a diagnosis, it might be a level 2. If you're using it to decide treatment, it's a level 3. If you use it to just, there's all these levels. Well, they said these are level 1 because they will not be used to diagnose or treat. They will only be used to advise, which I think is wonderful when AI advises us. But when you take that advice and enforce it as if it were law, without going back to do all the work necessary to make sure it's accurate, that's how you end up with doctors basically facing life in prison for treating patients they never treated. But most doctors would have pled guilty assuming that the evidence was accurate. And I have to tell you that most attorneys would not have fought for you. They would have assumed that evidence was accurate also. So
Sure.
I had never heard of this Cornerstone group, and I'm sure there's others. And you feel like that was critical to your defense. Cornerstone Discovery, you said.
Yes, Cornerstone Discovery, and the software that they use is called Junto. And you can look it up, junto.net,
Okay.
and you can see the capabilities of this software. It's a commercially available software, but also that you have to train it. So you have to train it on your evidence, on your discovery.
I got you.
You have to know which words, which search terms that you want it to go find for you.
So you have to train. So this is a newborn AI. It's a little brain is sitting there, and you're going to feed it all of your data and tell it what's important, and it's going to AI for you.
Yes.
These different things. I see. How much did that cost you, if you don't mind disclosing that?
It was quite expensive.
Rough guess.
It's at least a 6-figure number.
Oh, okay. So we're not talking $90,000, we're talking over $100,000.
Yes. Well,
Wow.
throughout the whole case, because
Right,
they
right.
will charge you, for processing the charge
The initial
is,
setup,
I think, three things. The setup, which is basically the importation of the evidence.
right?
That's a charge. They will charge you to warehouse and for you to use the evidence to search. They'll charge you a monthly fee as your case is progressing. And then when you're ready to go to trial, they will charge you they will send, we had a person from the company with us during the trial. That was the presentation, a
Oh,
discovery
wow.
person that was with us throughout the whole trial, 7 days, 8 days. He was there from 6 o'clock in the morning till 9 o'clock at night. And we can call him at midnight, and we need this piece of evidence and that piece of evidence. They had somebody with us. And so that's why it was quite expensive. But we had that person for the whole period of the trial. And a month before, coordinating with the attorney to present the most factual and the most evidence that would support our case, and to prepare our exhibits that we to cross-examine each witness. And some of the help and the assistance that we got were being able to. So, for example, we got the discovery, the evidence, and we knew who were the witnesses that the government was going to put, and we were able to actually query the system. Tell us all the evidence that you have that this witness produced. Emails, documents, payroll records, everything. And we would go through that to find documents that you can use for cross-examination and for impeaching that
I
witness.
see.
And we were successful in finding impeachment material for each witness to present to the witness and say, well, you're saying this, but in this email, you said something different. Explain to the jury why your position now is different.
I see.
And we had one of the main government witnesses could not come up with an explanation, and her only explanation was that this was not her email. She would never write an email like that we forged this email. And we said, well, hold on a second. This email was obtained by the government from Microsoft. We have how is it that it's not your email? That we had no possession of it. The government subpoenaed it from Microsoft, and you're saying it's not. And the jury started laughing. And we knew that main witness was impeached because that's the only explanation that they could come up with, that their position now on the stand is different to what they wrote many years ago, 7, 8 years ago, about their knowledge about billing codes and things like that. And this is a public testimony. It's going to be in the court docket. But the witness just said, this is not my email. You forged it. And the jury started laughing because that wasn't an out for that situation. And they didn't believe that witness.
That must have been a wonderful moment. They say there are no Perry Mason moments at trials anymore, but I think that's because no one actually does the work that a Perry Mason would. Now, so their defense was that Microsoft or the government had falsified an email in your favor.
Yes.
Now, you also had to pay separately. So this is a wonderful service. Sounds like it was worth well, obviously it's worth every penny, because my catchphrase is that a good defense will cost you a lot, a bad one will cost you everything. So you had to pay over 6 figures for this evidentiary service, and then
Yes.
you had to pay separately for the very thorough investigators you said you got from the Chapman
Yes.
Investigative Group.
Yes.
Was that also
That's another 6 figures.
another 6 figures? And then you had to pay your attorney, which in a case like this, I imagine was probably approaching 6 figures also, or if not surpassing it.
That is true.
So how much of a budget do you think a physician should have on hand to have a chance of defending themselves against charges like you faced?
At least $500,000.
Okay, 500K. And then what about the physicians whose assets are all grabbed right at the start, like Dr. Henson's was? Do you think they have any chance whatsoever at defending themselves
They
without
should.
access to any of this?
Now the law does allow them to use some of those assets for defense
If they're indigent.
purposes. What's that?
If they're indigent. No,
Well, I mean,
if they have no money to pay. If the government seizes all their assets and they have no resources to pay for any of this.
in terms of and that's one of the strategies that the government does
Yes,
is
civil asset
basically
forfeiture.
they'll seize all the money and then they won't give you anything to defend yourself. And partially some of the strategies that we used in my case was the fact that my malpractice insurance actually kicked in some money.
Did they really? That is
because
very unusual.
this was partially related to billing issues. I had a specific rider in the malpractice insurance that they would pay for billing issues. So they gave us some funds, and they were wonderful that they contributed to some of that.
That's very important.
I was also wise in 2012 at the recommendation of a fellow physician is that I purchased a policy called errors and omissions insurance. They kicked in some funds also.
Okay, errors and omissions insurance.
Yes, they kicked in some funds too to assist in the defense. So
brilliant.
So there may be avenues to and I tell people you have to decide. You should sell. I mean, if you own a house, you should sell it and live on the street because otherwise you're going to be living in in my case, the federal detention facility in Otisville versus in my house. I was prepared to sell my house and pay for the defense, even if I don't have any dime left, because the alternative was the federal detention facility in Otisville versus being at my home now 3-month post trial. So you have to be able to marshal resources because it's a game of resources.
Well, now let me ask you something. You have been acquitted by a jury in the United States of America where deference is given to the decisions that the jury make. Therefore, the Department of Justice has come to you and the OIG for the DHHS and has said, we are humbly sorry we made these mistakes, drug your name through the mud, and just about destroyed your medical career and your business and practices, and we're refunding you everything you've spent, and you have a letter of apology and exoneration? Or are they using their influence to try to get the state medical board, this is a trick question, to try to discipline you further? Have they accepted that you are innocent, or are they still arguing or pressuring anyone?
Actually, the Commonwealth of Pennsylvania is pretty unique. Once all of this trouble started, I contacted the state medical board and informed them that I was under indictment by the United States Department of Justice. The law in Pennsylvania is pretty unique. It's pretty physician friendly. So actually, they advised me that unless there's an actual sentence, so not just conviction, you have to be sentenced for them to start taking action against your medical license. And this is only specific for healthcare fraud. This is not related to controlled substance violation. If there's allegation of healthcare fraud, unless there's actually a conviction and an actual sentence, they would not take any action against your license. So I informed them I'm under indictment. They said if once you go to trial, there's a sentence and a conviction, you inform us. So we actually, after the not guilty verdict, we informed them, and they said, you have nothing on your license. You've never had anything on your license. Your license is clear. Now, of course, you've also written about my escapades with the Drug Enforcement Agency, and that is still ongoing. Hopefully they'll forgive us a little bit and let me go. But we don't know yet.
Right, right. It's been my experience that they never admit fault. Well, I'm not saying never. They never publicly admit fault. That they never back up and apologize. When a doctor's acquitted, quite often they will say the jury failed to convict, as if conviction had to be the only possible righteous outcome. And the doctor ends up. There are doctors who have killed themselves after acquittal. You're a psychiatrist. I'm putting that in your head. I know that you're much better off than that. You've got a loving family and support system, and I think every state should have a similar law to Philadelphia's. If we are truly innocent unless proven guilty, then we should be treated as such. You should not take away someone's livelihood based on accusations. And even if, right now, I don't give much weight to federal convictions, because knowing how the system works and that it's kind of a machine that rolls in one direction and everything is designed to come to the decision that they have already predetermined. It is Soviet to me. It's very different from when I started practicing medicine 30 years ago. So
And it's quite unfortunate now that the system is basically a conveyor belt system where you're presumed guilty unless you have the courage to be the person who wants to go to trial and may hopefully be able to prove their innocence. Hopefully, some of these Supreme Court rulings that came this year are going to be some chinks in that armor that the DOJ has in terms of their ability to prosecute physicians, to their ability to intimidate physicians. We're also thinking of are they running out of fodder for this fire that's eating the medical community? More than 80% of physicians now are employed by healthcare systems, and only 20% of them are independent physicians. And the majority, 95, maybe 99% of these prosecutions are related to individuals, physicians who are in private practice, who are practicing on their own. Rarely do you hear that they prosecuted a physician who works for a healthcare system. They would never dare to do that.
I find it shocking that a system set up that is an amalgamation of giant health insurance companies and federal law enforcement would somehow not find fault with the giant healthcare companies, but would instead stomp the independent physicians that are their direct competition. Right? This is almost like a reverse antitrust, where they're enforcing, if you're not a giant if you're a giant corporation like Boeing, you can be directly responsible for the deaths of hundreds of people and pay a fine, right? Because you have the money and power to fight back. If you are an independent physician, even a successful one, even if you're making millions of dollars, you have nothing compared to the resources of the federal government. So I think it's by design that way. I don't think it's some giant conspiracy. I just think that's the way those companies work. If they can stomp their competition, they do so. And when they were told, hey, what physician should we target? They said, wow, the little independent ones, of course. They're the really slippery ones. And they will impugn some sort of, well, if you're not with a big company, there must be something wrong with you. So it flipped. It used to be 80% independent, 20% with the big groups about 30, 40 years ago. It has flipped now to where it's 80-20, as you describe. And I truly don't think it is safe for an independent physician to practice medicine in the United States of America right now. Clearly not for practicing any sort of pain or addiction medicine, right? Because they are really on a roll there. But it appears that you can't even be innovative and help develop telemedicine. Do you think it is dangerous to be innovative?
You probably have to be affiliated with a gigantic health system or employed. You cannot be innovative in any way because they will see that as a fraud scheme. They always call it a fraud scheme. Even if you're doing telehealth that they wanted you to do, talking to individuals in rural Pennsylvania, and getting paid, and it's costing you more than they're paying you. It's still a fraud scheme. That was the fact that was demonstrated to the jury. One of the final witnesses in the trial was actually an agent for the Office of Inspector General for Department of Health and Human Services, and my brilliant lawyer asked him about the amount of money that the government was saying that we collected from Medicare. And there have been several witnesses who were nurse practitioners that said that they were working for me. And the lawyer just did simple math. He brought in a whiteboard and he says, well, nurse practitioner so-and-so said that this was her salary. Nurse practitioner so-and-so said that this was her salary, and nurse practitioner so-and-so said that this was her salary, and there is a coder and a biller. And I see that just their salaries ate up all the money that Medicare said that they paid him. Did you do a cost analysis? And the agent was actually a certified public accountant, was a CPA. And my lawyer said, did you do a cost accounting? Did you find out? You knew because you got all of his accounting, all of his bank accounts. How much did they pay electricity? How much did they pay their computer system? How much did they pay health insurance? How much did they pay rent? Did you do any of that analysis to find out whether they made money or lost money? And the agent said, oh, no, we didn't have interest in, and he says, okay, so you're saying he stole from Medicare, but you never did any accounting about anything that in terms of his practice. You never looked into any of that, but you're coming here telling this jury, this doctor stole from Medicare while they may have provided services at a loss to Medicare. And I think that was the last witness for the government, and the government didn't come back with anything for any response to that cross-examination, but that was what the jury was left with. And so the lawyer needs to be to know every nook and cranny of the case. We talked a little bit earlier about this company Dunn that the Department of Justice and the DEA is prosecuting. And they probably looked for the weakest link. They chose a company whose owner is a Chinese lady who's not a U.S. citizen, and basically they tend to individuals who are psychiatrically ill, who could easily be labeled as addicts or not with legitimate psychiatric illness. And basically they said it's all fraud, and we want $100 million back, and we want all the employees of that company to go to jail.
I was very surprised reading about that in the news, where the Justice Department said, and they switched to encrypted communications, thereby obstructing justice. I'm like, I thought that was the Fifth Amendment, where you're not forced to testify against yourself. Why should they? The first thing a good lawyer does is tell you, don't trust your communications, even with me, right? Use something encrypted or whatever. But I think
never talk to the police.
Yes, that's
never ever talk to the police.
Even the good ones have already formed a bad opinion of you, and that will color what filters through their minds. When you say something that can go either way, they'll flip it. And let me give you an example. Dr. Reach was treating addiction. Now, they've been hammering addiction doctors too, not just Dr. Meredith North. Dr. Reach was prosecuted, and he had told the lab companies, I don't want to make any profit off the labs, but please don't send my patients to collections because they're poor. This is a poor area of the country. At trial, the prosecutor turned that around and said Dr. Reach didn't want to send anyone to collections so they would have more money to give him. He was charging $125 per visit. I mean, a very reasonable fee. But that's what they do. They take any humanitarian or good acts you do and they can twist it in a way you would never imagine. I was certified to treat addiction as I had the X waiver and all that. One of the 3% of physicians willing to do so. And at trial, they flip that around because, you know, you're doing general practice, you've got a pain management, your pain management group. And I also helped establish the first Suboxone clinic in this area and was helping with that. I only ever had one patient out of like 10 years, 12 years of practice that went from one side to the other. Now, I did have patients that I found had a problem and said, hey, here's where you can get help and whatever. But once I started treating, there was only one patient that ever left for misbehavior and then come back saying, hey, I have an addiction. But they argued to the jury that the fact that I treated addiction proved that I wanted to make money getting people addicted and make money after they were addicted. There's nothing you can do so good that they can't turn around on you. Now, did you testify in your defense?
I did not testify in my defense. We got to a stage where my lawyer felt that we had a significant headwind that was pushing us toward a not guilty verdict, that he didn't want to open new avenues.
Right.
He felt that if I had testified, they would have had an opportunity to ask about other things that would smear my image in the eye of the jury. And so he said, I think you shouldn't testify. We only had 2 witnesses, and we had several character witnesses, a lot of my employees, a lot of my patients. And that's another thing that is very a big piece in terms of being able to prove your innocence, is to be able to tap into patients that would show that you're a compassionate, well-meaning physician. In my case, this patient was actually somebody who had severe psychiatric illness. She was the daughter of 2 nurses, and she had severe psychiatric illness, and I engaged her in treatment. I did psychotherapy. I gave her medications. After 2 or 3 years of not leaving home, she became better after treatment with psychotherapy and medications. She actually started leaving home. She went back to college. She graduated college. She went to nursing school. She finished nursing school.
Wow.
She became a psychiatric nurse on an inpatient psychiatric unit. And she told all of that to the jury. And she said, this is an excellent doctor. He saved my life. He does psychotherapy. He helps people. And she started crying. And she said, release him, release him, release him. She started crying, and she went kind of talking to the jury. And some of the jurors started crying based on her testimony. So bringing in compassionate patients that would testify and demonstrate that you are a good physician, that would counter some of the scandalous allegations that the government does. In a similar case, there was a physician in Kentucky who was prosecuted that the Chapman group helped. And he's a physician also of Syrian ancestry like me that I've talked to. And the Chapman group was so wonderful. That physician, actually, there was controlled substances allegation against him. It wasn't just healthcare fraud. So the combination of controlled substances allegation plus healthcare fraud together, that the government now is using as something that would pressure physicians to plead. And he knew he didn't do anything wrong. The Chapman group found witnesses. They found 2 witnesses. They found a patient of his who's a pharmacist who testified that his prescribing patterns were within the norms. He never suspected that he was diverting or doing anything. And then they found another physician who was his patient, who testified to his impeccable reputation in the community. And then several physicians who were his hospital colleagues testified on his behalf. But if it wasn't for the Chapman group being able to marshal some of those witnesses and some of those resources, the jury would have been left with the government's impression about this physician, that they were a physician who prescribes willy-nilly and basically prescribes inappropriately. But when you bring a witness that will testify to the fact that this is a physician who prescribes reasonably. So a lot of these cases are very intensive in terms of witnesses, experts, character witnesses, as well as patient witnesses that would be able to turn these cases around.
And I think that's something that's important to mention, is that they absolutely destroy you. A grand jury is not based, the evidence presented to a grand jury does not have to be truthful. It does not have to be honest. It does not have to be accurate. It will never be double checked. They will never be called on anything they say or do there. They were created as secret to protect the reputation of the defendant. But actually what they are is sort of a rumor generator, where the grand jury's decision is released to the media. And long before you get to say a word in your defense, the newspapers have already blasted out everything that the government says about you. And if you're unlucky, they have a press conference. Did they have a press conference about your charges?
There was a press release. Absolutely.
Always helpful, always helpful. And I have found that hardly anything in that initial press release is found to be accurate, even when someone is guilty, right? Much less when they're innocent. And so it is important that you're facing a strong headwind. There's a lot for you to overcome. It's very likely the jury has read, or even if they don't remember reading, has seen some of that, and they have a bad impression of you. Now, with doctors charged with overprescribing, there's a special animus to that, because we have these movies out: Pain Hustlers, Painkiller, I Like to Dope Sick. But Pain Hustlers is the closest thing to our new reefer madness I've seen.
Sure.
It's way over the top.
I'll tell you a funny story. I mean, to me, it didn't seem funny, but maybe you and your audience would appreciate that. This was jury selection. So in my jury selection, they basically brought in about 70 individuals from the district, from the Eastern District of Pennsylvania, which includes the suburbs, some of the suburbs of Philadelphia, the Lehigh Valley, and it goes down to Reading, Pennsylvania, which is a rural area. So they collected about 70 registered voters from that area to be in the jury pool. And one of the questions to the jury was, did you hear anything about this case? So there was only one juror that raised their hand and said they've heard about the case. And I didn't participate in that, but my lawyer told me the story. So they brought in that juror to talk to them about what they heard about the case. And she said that she had read the news article, and even went further and said, well, in the news article, they said that Dr. Rifai stole from Medicare $1 million over 7 years. What kind of loser is this doctor? What kind of a fraud is this? $1 million over 7 years. So he's doing a fraud for $100,000, $125,000 a year. What kind of loser fraudster is this?
That's an important point, because we see 70 and 80-year-old physicians going to prison on these overprescribing charges, when I think they just haven't kept up with the times. They don't realize what the threats are, and that things have changed, that you can no longer practice according to your education, training, and experience. You have to practice according to what Dr. DEA wants you to do, or thinks
Yes.
you should do. And so I don't think they waited till they were 75 and said, you know what, in my golden years, I've decided I don't want to retire and use my retirement account and everything I've put back over the last 40 years. I want to go to federal prison, so I'm going to do a Walter White impersonation and go ahead and break bad. And usually it's over what to doctors would be tiny amounts, right?
Mhm.
But to the general jury, to the general public, if they throw up a figure like $600,000, they say, wow, lots of people would. Well, physicians, if they're doing well, they'll make that at least in a year or two, and they're not going. And if they're entrepreneurs and they have clinics and all that, of course, that's going to do more. So they're not going to, in general, risk their entire life and future to do that. Now,
But this juror was saying that the government case is
he
bogus.
saw
I mean,
that, or she
even
saw that.
she saw that. She said 7 years, $1 million. What is he doing? Why would he do that? If he got hospital employed, he would have made more than this. So even that juror, just in simple math, saw that the government case was not cogent to start with.
Did your attorney say, Your Honor, this juror is acceptable to the defense?
Actually, the government objected because
I guarantee you they did. I guarantee you they did.
They said she couldn't be rehabilitated. She's done.
She couldn't put it
done.
aside, of course. If it had been the other way, if she had said, what an evil man, they would have said, well, she can put that aside. Well, I so much appreciate your time. Is there anything, any last message, important message that you want to get across to the viewers, most of whom will be physicians, but many of whom might be patients receiving treatment, just so that they understand what their physicians are facing or what the doctors are facing?
There's hope. I think hope is coming, and I hope that we're going to be able to continue to provide adequate services to our patient population, the indigent patient population. The practice of medicine is very, very difficult now in the atmosphere in the United States. Hopefully, some of loosening of those regulations that had made the practice of medicine a difficult endeavor in the United States, especially if you're in private practice, and especially if you're caring for the people that are. I know a lot of people in who advocate for these patients. They call them the dispensables, the ones that the society thinks that they're on the fringes, whether they're on psychotropic medications, whether they're on ADHD medications, whether they're on anxiety medications or pain medications. These are not addicts. These are not individuals that are criminals. These are not individuals that divert their medications. These are individuals that use their medications appropriately to help them stay functional and help them function in their life. And to kind of deny them that, I think is a travesty that we're experiencing in our society. And hopefully we're going to be able to continue to provide services for these individuals.
Well, I think that's a wonderful place to end with a little bit of an addition from me. It is only through physicians like you who are willing to risk everything to stand up for their principles and fight that it's possible for us to know the extent of the falsehoods that they claim and the innocence of the doctors that are accused. If people like you don't stand up, and you're one out of how many thousand, none of the rest of us and the patients don't have a chance. So we appreciate you.
I want to add one more piece, and this happened to me yesterday. I didn't want to talk about it, but it's just in me, that kind of filling me with fury. One of the pieces of evidence that the government utilized to say that my services were inappropriate, they used a publication from the Center for Medicare Services that is called the Local and National National Coverage Determination, an LCD or an NCD. And basically, it's a document that Medicare synthesizes to say what are the parameters that services could be provided. And in my case, this document is related to psychiatry and psychology and describes what psychotherapy should be. So when I was indicted, I sent a request, a Freedom of Information request, and this was sent in January of 2023, a Freedom of Information request, and I said, this document that you have for psychiatry and psychology that describes psychotherapy, who authored this document? Can you tell me the names and the degree and qualifications of who authored this document? So I can at least figure out who is it Dr. Sigmund Freud? Is it Dr. Beck? Is it Dr. Irvin Yalom? A prominent psychiatrist contributed to this document. I just received a response yesterday. I'm going to post it publicly from the Center for Medicare Services Freedom of Information response. After thorough search in our database, we could not find who are the authors of this document. Zero information. So they are going to, they indicted me, and they were going to send me to jail for 40 years based on a document where we don't know who authored that document. It's a sub-regulatory guidance, but we do not know who authored that document. And it describes the practice of psychiatry and psychology in accordance with Medicare. It's the national coverage determination for psychiatry and psychology. And we do not know who authored the document. Medicare has no record of who authored that document.
But they're using it to send dedicated physicians who are creating and innovating for the future of medicine. They're willing to send someone to prison for decades on the opinion of someone that they can't even identify.
Yes. Or ask for money back from physicians who provided services, and they say, well, your services are not compliant with the national coverage determination for psychotherapy. Give us back $2 million. You're bankrupt. They bankrupt the practice. They say everything that you did is zero, according to this document that we don't know who published.
You
And
failed to comply with the opinions of somebody.
Somebody that, and we can't tell you who it is. We have not. We don't have anything in our records about who. And I've been furious since yesterday, since I received that email from the FOIA division for the Center for Medicare Services. I may write an article and include that document.
I sincerely hope you will. It is critical that people understand that the standards that the government is using to go after people are not evidence-based, reasoned, rational practice of medicine standards. These are just someone's opinion, and quite often they're extreme opinions. You know, a psychologist might have written it and said psychiatrists should only prescribe medication and should stay out of psychoanalysts, because maybe they think that. That doesn't make it right or true, and I would argue that when there's a civil penalty attached to it, that's wrong. When you're talking about criminal prosecutions, taking away someone's life and liberty in the United States of America, it should be absolutely illegal to even indict someone without absolute clear evidence of criminal conduct. And I think that's what the Supreme Court tried to do for us. And I think it's being ignored largely. But Doctor, I thank you for your time so much. And I am very happy for you. And I expect to hear great things from and about you. And I look forward to rebuilding things and making things even better than they were.
Thank you. And my hope is me speaking up, despite the loud noise behind me, that I should stay quiet, and I should return to practice quietly, because they will come after you again. They will come up with other things,
right?
To come after you again. Maybe I'm apolitical, but maybe that person who had blood dripping on the side of his face and clenching his fist and saying "fight," I'll listen to him.
Yeah, it is it is an interesting time in our country, and something is going to change no matter what. Um, Something almost has to change. But I will give you a military analogy. It is always safer for the individual soldier to keep their head down and not pop up out of the foxhole or out of the trench to take a shot. But that is how you lose wars. If someone's not willing to pop up and be a possible target, then we will absolutely lose. And this is clearly, the war on drugs has become a war on medicine, a war on physicians. And the DEA said, the government said, let's go where the money is and the guns are not. And I think that's what led to this. So let's both hope that no matter who wins, something drastically changes when it comes to the criminalization of medicine in America.
Very good. Thank you for having me.
Have a beautiful day.
Take care.